May it please the court. I'm Joel Walters. I'm here for the plaintiff appellant Beth Helmick. I'd like to reserve 5 minutes for rebuttal. This is an appeal from a final order granting summary judgment in favor of the defendant, Aaron Taylor, as to the complaint filed by Beth Helmick, and denying summary judgment as to the counterclaim that Mr. Taylor filed against Beth Helmick. The nature of the dispute is over a breach of a marital settlement agreement. In 2016...
So we read the record. The bottom line is Ms. Helmick a third party, an intended third party beneficiary of this agreement or not, right?
That is correct.
And so I have a question for you. If we make a rule that Ms. Helmick is a third party intended benefit, an intended third party beneficiary of this thing, then why are not Chase, Wells Fargo, Barclays, MB Financial, Blue Promise, Discover, and all the other creditors who are listed in this marital settlement agreement, how are they different? Why aren't they? And then they all have classes of action that are sort of insulated from other defenses, like this one would have insufficient documentation of the actual life of the loan. But that just doesn't make sense. And you've got to confront the case, the principle that where an agreement doesn't provide the third party a greater benefit than what was already owed. That's not a direct, not an intended beneficiary. And the fact that they're mentioned in the contract, this marital settlement agreement, doesn't mean that they're part of the beneficiary. So I've just told you everything I have concerns about with the case, and I'd like to hear your response.
Oh, absolutely. Well, first of all, to answer your question, I've never seen a large creditor such as, a credit card company or something get as granular as seeking recovery under a marital settlement agreement.
But that doesn't change. If we do what you want us to do, then we can write an opinion saying that she's an intended third-party beneficiary. How is she different, other than the fact that you've never seen a large commercial creditor, which isn't going to work its way into an opinion? How is she different? What makes her different than everybody else who, marital settlement agreements routinely list out the creditors of both sides and arrange for the payment of those marital obligations? And to do what you're asking us to, it suggests to me that we're going to open the floodgates to everybody who's a creditor in a settlement agreement. And under those circumstances, since they can just go after the encumbered party, they don't have to prove their claim. They just can sue for the amount like she did here, or claim that amount. And that just doesn't seem like the correct practical outcome here.
Well, and I'll try to address the cases. The bottom line is, ever since the Florida Supreme Court in 1933 wrote the opinion Mariana Lime Products versus McKay, and this is cited in the trial court order under review, it's cited in the appellate briefs. The Florida courts have recognized that where you have an agreement requiring payment to third-party creditors, that is enforceable by the creditors. And
Mr. Walters,
yes,
I'm going to interrupt you. Let's get to basic principles.
yes,
A divorce proceeding entails divvying up the marital assets and marital liabilities. Correct?
correct.
It is a proceeding in which the former wife and the former husband agree, or at least take the judge's order as to how they are going to address those liabilities and assets, correct?
Correct.
It really just lays out the future as between those two spouses. That's a basic principle of divorce proceedings.
Well, this court in Potts versus Potts and the first district in Farnsworth versus Farnworth held that a third party could enforce an obligation that was owed to it pursuant to a marital settlement agreement.
That was the lawyer case, right?
No, that was a case in which the former husband's obligation to pay for um, son or daughter's college expenses was memorialized in the marital settlement agreement. There wasn't any independent child
Who
support.
enforced it?
Excuse me?
Who enforced it?
Who enforced it? In one case, it was the son, and in the other case, it was the daughter.
The party's child was able to pursue this relief based on what the parents had agreed to.
Yes, in that case,
And
it
so
was
that's not the same.
as a mother. Okay, I don't,
Let's put it, when the trial court adjudicated the cases that you just referred to, obviously the children, either minors or close to it, and they were part of what was adjudicated, their rights and welfare, as opposed to their status as a creditor.
that is not correct. In one of the
Wait,
cases,
you're telling me that a child who's dependent on his or her parents, and who has some reasonable expectation that they're going to pay for a college education, their parents, that's the same as somebody's mother-in-law?
what I'm
In terms
saying,
of what the trial court's jurisdiction was here, and,
well, the third-party beneficiary was an adult in one of the cases. But again, going back to the principle, third-party beneficiary rights can be conveyed under an MSA. They can be conveyed to a person.
well, they
who's-
theoretically it can be, but here, your client occupies the same status in that MSA as every other commercial creditor, and those liabilities were simply divided up between these two people. I in agreed amounts, which I think according to your client was less than what she thinks she might have owed, but she didn't have records of what she was actually owed to prove that up in an independent proceeding. So this seems like a good vehicle, right?
Well, again, going back to that scenario, if in fact,
I mean, she's no more than mentioned in the agreement, she's identified, that's it. And our case law tells us that identifying somebody in the marital setting, in any agreement, doesn't mean that they're a beneficiary, that's the Peters case. And, or at least federal case law, like Florida law. And it also didn't give her anything better than what she already claimed.
well, first of all, there isn't a case in Florida jurisprudence, and probably in American jurisprudence, where somebody has been identified by name and a payment amount with an obligation of one of the contracting parties to pay them that's been determined not to be an intended third-party beneficiary.
Is there any case where somebody like Capital One, who's listed in an MSA, has brought a claim to enforce their status as a third-party beneficiary?
In an MSA, no. In other types of agreements, yes. And one of which is the Mariana case. That case involved a stock purchase agreement. Stock purchase agreement required the purchaser of the stock to satisfy various obligations of the company that the stock pertained to. They were listed, and yes, if that would have been large creditors, small creditors, that's an intended third-party beneficiary. Another case that's been briefed relates to a settlement agreement. That would be MI LLC versus Utility Directional Drilling, a third district case. In that case, a general contractor entered into a settlement agreement with a prime subcontractor. The settlement agreement required as a condition of settlement that the subcontractor pay all of the subcontractors that had gone unpaid. And one of the subcontractors brought a claim to enforce his rights under the settlement agreement. Again, he was a third-party beneficiary because, again, one of the foundational requirements.
These are commercial transactions, and just as Judge LaRose was pointing out, this agreement in the free-end world, the husband and wife have made this agreement to settle once and for all what is owed to each other and what can be expected from each other. It doesn't have language or context that would lend itself to the analytical framework that you're describing in a stock purchase agreement or a commercial relationship, where you're addressing those issues as part of the deal. And it, you know, she's lumped in here with Chase, Barclay, mortgages, And on the right side, you know, what looks like a student loan, Discover, Bank of America, TJ Maxx. I'm just, without more than being named and being given a benefit that is the same or worse, theoretically, same or worse than what she could recover independently, because she could certainly bring a direct cause of action against Aaron for these loans.
Well, and again, the whole concept of third-party beneficiary means that Beth Helmick and the grandmother, Catherine Anderman, could have done nice things to the marital couple through their time. And the wife says, well, okay, let's enter into a marital settlement agreement. It's really important to me that we do something nice for mom and grandma because they were nice to us. It doesn't matter whether
Were we
mom,
being nice to Chase and Bank of America because they did nice things for us?
no, I think those are probably listed for other reasons. But my point being that if the parties entering into the marital settlement agreement indicate, yes, we're going to create an obligation on Mr. Taylor to pay this amount of money to the mother and the grandmother.
Well, wait,
It
Mr.
does-
Taylor theoretically always had that obligation, right? Otherwise, it wouldn't have made its way into the MSA.
Well, I think that's really far afield because he's done everything he can, even after being sued, not to pay that obligation. And so,
Take a step away from a third-party beneficiary. If, let's assume your client is a third-party beneficiary, does your position result in her getting a windfall? Because I understand the record. We don't know what's owed, we don't know what's been paid, we don't know what the principal amount is. The only thing you have is what the two parties to the MSA agreed to.
well, I don't know that that's a fair reading of the record. We've also, and the record also includes the affidavits of Beth Helmick and Karen Helmick. But putting that issue aside, let's take your question at face value. What if the case is remanded and successor judge or whatever says, well, you know, I agree they're third-party beneficiaries, but I believe Aaron Taylor can be believed by saying there's a computational error in this, okay? Well, there's several issues involving that. Number one is if this is an MSA, and it is, if it was reduced to a final judgment, it is, he has an obligation, if he's claiming that something was not properly reflected in the agreement, to follow appropriate procedure and within the appropriate time limit, move to have that changed, which he did not do. When he brings it up as a counterclaim, again, I go back to the whole body of case law on third-party beneficiaries, which is that you don't need consideration flowing from the third party.
But let's go back to the
Yeah.
law school contracts.
Yes.
Typo. I agree with Mr. Wallace that I will pay him to paint your house. And he doesn't paint your house. You can still enforce that contract because that is an example of clearly there's no question you're a third-party beneficiary.
Your position strikes me as so far afield from our first aid contracts class.
Well, if the court takes a look at what is said in Mariana, and Mariana, it provides a splendid example, which is taken directly from the restatement section of contracts. And basically, the example is A agrees to pay party B a debt that party C owes to party D. Party D is an intended third-party beneficiary, and party D can sue party B if party D doesn't get paid, even though party D never provided any consideration to B and never provided any consideration to A. And the reason is because A, in entering into an agreement with B, said, I'm going to enter into this agreement in consideration for you taking care of party D, okay? And so whether or not party B thinks that D is really owed the money, or party D is deserving, or
Where in the agreement did the parties manifest a clear intent, aside from naming her as a creditor? Because that's not going to be enough. Where is the clear intent that she should benefit from the contract? The fact that she might generally benefit, obviously that's an incidental beneficiary. But to be an intended beneficiary, the whole reason intended is used is intent. And if there's an intent to benefit her, then there has to be an intent to benefit the rest of these creditors.
there is a huge difference
How's that?
under Florida law between merely mentioning somebody in a contract and creating a payment obligation for one of the signatories to the contract to pay a named individual a specific amount. And I will submit to the court that there is not a single case in Florida or anywhere else that I could find where, when that's happened, the third party has been found not to be an intended third-party beneficiary. And the rule in Crabtree versus Aetna, which is also cited in the trial court order, cited in the briefs, it talks about a presumption. And it states where a contract creates a right or imposes a liability in favor of a third person, a presumption arises that the parties intended to confer a benefit upon the third party and give that person the right to enforce it. And that's squarely the situation here. Helmick and Anderman are specifically mentioned by name in the MSA, along with the amounts that they're owed, and there's a specific obligation of Taylor to pay them. And that is enough.
But that's the same for all the other creditors, and they aren't intended beneficiaries.
Well,
Mr. Walters, if I may interrupt you for a moment, I wanted to answer Judge LaFleur's question, but you're into your rebuttal time.
oh, okay.
We've been peppering you.
Well, that's okay. It's more fun to answer questions than to present argument anyway. But getting back to your question, in the eyes of the law, I believe that AT&T is a third-party beneficiary. Now, I don't know why it would want to pursue a claim through the marital settlement agreement, or how it would even know about that.
Statute of limitations have run out, AT&T's dead, and this is an easy way to run out.
Well, again, if the parties to the contract, I think what the court's forgetting is really the kind of an overarching concept here. Who knows whether Karen Helmick would have agreed to sign that document if mom and grandma weren't taken care of? Who knows if she'd agree to say, well, okay, Aaron, you can have the business. It's yours. These are trade-offs that went back and forth and were negotiated and were important to these people. And to now say,
As to who was going to incur a liability or be given an asset, is that between the former spouses?
well, it is until they provide somebody by name with a benefit, as they did in the first DCA case and the second DCA case.
This was a pre-existing obligation that we created one, and the benefit that was provided to her arguably was less than, not more than, what she otherwise might have been entitled to receive from Aaron. That has to be the case. Because under your theory, and I picked it up from your briefing, she might have been owed as much as $100,000.
Well, let's say
And
now,
that's an important fact, because to find an intended third-party beneficiary, the benefit has to be the same or better than what that entity or person was entitled to in the first place.
well, let's say that Aaron had defenses to the claim. If these claims were pursued, Aaron had defenses to them. They sit down to the negotiating table for the marital settlement agreement and says, well, why would I pay that? I'm not going to do that. I've got defenses to the claim. And Karen says, well, you're going to do that.
But she's not going to be there, because it's not her marriage that's being dissolved.
Karen is
Oh,
going
I'm sorry.
to, Karen is going to be
Yeah,
there.
okay.
And they sit down and
So
they
they liquidate the number.
and they hash it out. So that's a situation where for the court to come back and say, oh, well, you woulda, coulda, shoulda done it differently. Well, this is how they did it. And the case law is very clear. you don't need to have new consideration. You don't need to have any consideration. But the cases I've cited, Mariana and MILLC, those all involved pre-existing debts. There is no requirement in Florida law that you can't be a third-party beneficiary if the benefit is to pay an existing debt. And so again, whether it was the third-party beneficiary claim is worth more or less is not really the issue, because this is what they agreed to. And parties, even if the amount would have been zero, Aaron Taylor and Karen Helmuth can still sit down and agree that mom and grandma get paid, and that's what they did.
Mr. Walters, you've used your time, but we'll give you a couple of minutes on rebuttal.
Very well, thank you, Your Honor.
Thank you, sir. Mr. Wallace?
Good morning. David Wallace from the Bentley Goodrich and Keeson firm in Sarasota. Helmick was only an incidental beneficiary. There was no intent to confer a direct or substantial benefit on Helmick or Anderman by including these debts in the list with the other creditors in paragraph 3 of the MSA. It was not a direct and primary object of the MSA, particularly paragraph 3, to confer a greater benefit on these creditors. I'm going to pick up on a couple of Judge LaBritte's comments from your very beginning. Listing these two folks in paragraph 3 is not different than listing all these other creditors. It's exactly the same because the language is the same. They're not treated any differently. And there is no greater benefit intended, and that picks up on that excess case that we cited. And as Your Honor said, citing the Peters case, mention in the MSA is not enough. All they're doing is listing what they believed to be existing debts. Your Honor also asked another question.
Mr. Walters
Yes.
is telling us that everybody who's listed qualifies as a third-party beneficiary.
I disagree.
Is there a case, I know there's not a case that says you can do that in this context. Is there a case that says you can't do it?
Well, I think there has to be an intent. I'm going to have to get my language right. An intent to confer a direct or substantial benefit, and if somebody already owes you X amount of money, just listing that debt and putting it in a list and stating that somebody who already owes it is going to pay you, that's not a benefit. So just putting it in a list does not make it a benefit. There has to be an intent to create a substantial benefit. And my starting point on this is when I look at the MSA, Your Honor cited to the general overview, which you should, because I think it's the A.R. Moyer case that talks about looking at the context and looking at the contract as a whole. But what the parties memorialized was what they understood to be their existing debts. And on that, we can look to paragraph 3, and the introductory words tell us almost everything we need to know, which is, during their marriage, the parties incurred certain debts, past tense, and they list them. So the record doesn't support any kind of theory that there was intention to create any kind of a new payment obligation. Again, during their marriage, the parties incurred certain debts, and then they're listed. And that's why when the trial judge made his findings, he said the unambiguous purpose of the MSA was to divide up what the husband and wife understood to be existing liabilities. That's consistent with what we see on the paper.
Help me understand, because I didn't pay very close attention to this. Didn't Karen, the wife, give up her interest or claim to the husband's business? She got, they did an equitable distribution, and she ultimately walked away from the business. And these loans were made for the benefit of the business, which he kept, right?
He kept the business.
Right.
I actually don't, I have to confess, I don't recall what her waiver of
I
rights
didn't
to the
try to go
business.
through the minutia of exactly how that was executed, how that was worked out, but at the end of the day, it makes sense that the person who keeps the business that was funded, at least to some extent, by this advance from Ms. Hellman, that he would maintain that encumbrance after everything else was divided
Sure,
as part of the deal, right?
Sure.
That's what I'm asking.
sure. It's a logical divvying up of their liabilities in that sense.
And it didn't, the obligation for 46,000 was not more than what had originally been claimed. In fact, it looks like it was a little bit less.
Well, it's obviously very murky. They loaned something north of 100. It's unclear what was paid back. It's unclear what was loaned.
How it was treated during the time that the loans were made. But at least it was more than 46,000. And
Right.
I think the record is, we could probably all agree, even your opponent, that more than 46,000 flowed from Catherine and Beth
Absolutely,
to Aaron.
Absolutely.
Under the heading of money for the business, one way or another.
absolutely. And that brings into my mind, I think Judge LaRose, in one of your questions, you made reference to the lawyer case, and that's the Palomino case. And Palomino is different, and that kind of illustrates most of what we need to know here, I think, in that in Palomino, there had been an attorney's fee award that got set aside, and the amount got set aside, and then there was going to be a new hearing, and the other two parties agreed what they're going to pay the lawyer, and they put $10,000 in this agreement, said we're going to pay the lawyer $10,000, and that was fine with the lawyer. It's a newly created obligation. That's the difference.
When you say that, were these loans made to the business or to the individuals?
I think that's murky. I think that's murky.
They sound.
And it might have been some of each.
If they were made to the corporation or the business, maybe this MSA creates a new benefit to have Mr. Taylor personally liable for the obligation as opposed to the business.
But I think that the record doesn't support that.
Okay.
I think that, you know, there are certain hypotheticals we could come up with, and that might be one of them, where you could say, oh, that is a newly created obligation, but the record doesn't support that finding here. Here, what they said in their agreement, which is where you're supposed to look first, is we incurred certain debts and here they are. So that's our existing obligations.
So your view of that is it was Beth and Aaron, either individually, collectively as a married couple, or the business of which they were both then partners, for lack of a better term, was the recipient of the funds.
Yes, but again, you know, with no documentation, I don't think we can say exactly what it was, but I think certainly some of it was to benefit his practice.
Look back,
Right.
These funds were distributed or dispersed to this couple who were running this business, and however the checks were made out or payments were identified, at the end of the day, it was for the benefit of the couple and derivatively their business. And then now we're dividing it up on the back end of the dissolution.
Right. And to your point earlier, to the extent that he's the one who kept the business and he's the one who got allocated the liability in the MSA. So it makes a certain amount of sense there, but what it is not on this record is any kind of new, greater obligation, greater benefit. And so that's the missing part is where's the benefit? It has to be a benefit. So when we look at TJ Maxx, for example, you know, if TJ Maxx is owed $5,000 and you put them in the list and it says TJ Maxx is owed $5,000, there's no benefit there to TJ Maxx. It's just their liability on a list.
This document doesn't spell out a number, figure, for anything.
You're right.
But
You're right.
Ms. Hellman and Catherine.
You're right. It does not list the others. You're correct.
But it does identify the accounts by number, which we don't have, they're redacted, but that seems to be what the redactions are.
Yes, you're correct. It does not have the numbers. The redactions were the account numbers,
So
I
it would
think.
be easy enough to discern the amounts that were owed to each of those creditors
Right.
as of the date of the marital settlement.
I guess I'll rephrase my point to be something like there's nothing in the language of this MSA that suggests that they were changing the amounts owed to TJ Maxx or the credit card company to give them some sort of greater benefit by virtue of this MSA. And if they, absent that, if we go back to the original point, absent that, they're exactly the same as the Helmick and Anderman. They don't have, there's no greater benefit. So if they were all third-party beneficiaries, then you would have a floodgates problem. I can't believe I didn't make a floodgates argument. It seems to be one of my favorite arguments these days, but I don't think it found its way into this brief. And then we get into briefly, we get into the broader point, which is, and I brought these things up in our brief. They weren't brought up in the initial brief, but I brought these things up in our brief because in the initial brief, they said that they should have gotten summary judgment for her, and that this court should reverse and grant, direct the court to enter summary judgment for her. Well, in response to that, I brought up all these findings she had no idea how much she loaned, she had no idea how much was paid back. And under these findings, I don't think there's really any, and then there's the other one, which is when they dug into it, Helmick and it looks like Taylor paid back more, $30,000 or $40,000 more than he was loaned. Looks like he was loaned 143 and paid back 171. So you get into all these findings when they want summary judgment for them. So I don't think there's any scenario where when you start peeling back the onion, where they would get a recovery on remand or otherwise. I've already addressed Palomino. That being the case, I'm open to any questions. Otherwise, I'll just wrap up.
Very good. Thank you, Mr.
Thank you.
Walters? Your 3 minutes of rebuttal, is that all right?
That would be fine. I appreciate the accommodation. Again, the point was renewed that under the marital settlement agreement, the payment obligation to mom and grandma were not a new benefit. It was something that was already owed. I would urge the court to take a look at Mariana, MI LLC, and other cases that have been cited, which clearly stand for the proposition that to be a third-party beneficiary, the obligation does not have to involve a new obligation. In both of those cases, these were pre-existing debts. The parties chose to list them, and the parties chose to create a right in them to enforce those benefits. As to the...
Suppose the parties didn't enter to an MSA, and they were fighting everything about who owed what, and the trial court enters a final judgment of dissolution, but lists liabilities and assigns it to one or the other. Does that create a third-party beneficiary situation for Ms. Helmick?
No, not at all, because it's not a bargain for exchange between the two parties. And that's really the key here. We can't sit here today and say what Karen and Aaron would have done if these obligations, if he was unwilling to pay these obligations. But by creating third-party beneficiary rights, maybe you create a cause of action that might not have existed because of a statute of limitations, or because of, in this case, large transactions going back and forth over a period of years involving revolving loans. Beth Helmick hasn't been involved in the company records for 2 years because the divorce was filed in 2016, the marital settlement agreement in 2018. Maybe the parties don't have a good handle on what's owed, but this eliminates that uncertainty. It gives the parties the right to liquidate that amount, create a right to enforce it, and that's what we're trying to do. And that was the intent of the parties to the marital settlement agreement, and the court should honor that intent. Thank you.
Thank you. Thank you both, gentlemen.
Thank you.
And with that, we are
All rise.